The Trust Indenture Act has been making waves in recent restructurings. Here to tell us more is Ronald Sarubbi, a partner at the Financial Transactions and Restructuring Group at Perkins Coie. So what exactly is the Trust Indenture Act and why is it important?
The Trust Indenture Act was enacted in 1939. It grew out of some New Deal securities legislation whereby the SEC was mandated to conduct studies by Congress after the stock market crash in 1929. So what the Trust Indenture Act does, it provides enhanced protections for bondholders, and it mandates how issuers behave with respect to their bondholders. It provides to have an independent trustee that's free from conflict of interest to oversee the workings between the company and its debt stakeholders.
And how is the Trust Indenture Act impacting restructurings? Well,
there's always been this kind of give and take between debtors and creditors of the company. And we've seen the Trust Indenture Act recently being used as an offensive weapon, really, in some restructurings. One recent case that comes to mind, a parent guarantor tried to remove its guarantee outside of a bankruptcy restructuring by getting a majority of its bondholders to agree to that removal and paying it a premium. So what happened, though, was upon an order for a motion to dismiss, the judge denied the order for the motion to dismiss and said the plaintiff's suit could go forward, that the removal of the guarantee was akin to depriving those holders to receive their principal and interest. And under the Trust Indenture Act, you need 100% of the holders to agree to any impairment of their right to receive principal and interest. In another case, similarly, the fact pattern was pretty much similar, but what happened in there is they tried to get an injunction. And the judge in that case did not grant the injunction, but said that the plaintiffs could very well prevail on the merits. So you see, when these two cases are taken together, it could be used as a weapon, the TIA, for plaintiffs to hold issuers to the task and make sure that they can't skirt the process of a restructuring by not involving 100% of the bondholders when trying to play with their principal and interest payments that they're due.
So does this mean we'll be seeing this issue coming up more in the future?
I think so. If those two cases are any indication, even though the judge in one of the cases has said this is a pretty scant area of the law, there's not a lot of case law, and it's been around for a long time, so some of the issues are pretty well settled in just the way they come out in practice. But with the rise of activism among bondholders, purchases that get done in the secondary market, and in light of those decisions, I could see in the future plaintiffs' lawyers and debt holders, getting pretty creative to use the TIA to say, hey, look, you can't impair our ability to collect our principal and interest without all of us consenting, to that process. One case that's also interesting, it didn't apply the TIA to holders of mortgage-backed securities. I think the plaintiffs in those cases tried to sue the trustees to say that the TIA should also apply, but the court differentiated the mortgages, the MBS securities from traditional debt securities because the payments there were contingent upon the underlying mortgages being paid. So they didn't go as far to apply the TIA to holders of MBS certificates.
Great. Well, this is all really interesting. Thank you so much for being here.
Thank you, Jamie.
For The Deal, I'm Jamie Mason speaking with Ronald Sarubbi. Thank you for watching.